almost always do, we first check with the DPCI, because many of these matters tend to be with the DPCI. We call the head of the DPCI in Gauteng, Major General Kadwa, to say to him, General, we have a cyber warrant for the electronic devices, whatever they may be, for one Mr. Kat Matlala. Do you have those devices so that we can then execute an access warrant, because these have already been seized? Major General Kadwa indicated that he's not aware of these matters, would find out where the matter was. But in that time, we were able to engage the Office of the National Commissioner, and the National Commissioner then indicated that the phones were seized by the PKTT, and that he would arrange through Lieutenant General Khumalo for those devices to be made available. During the course of that day, a police official, we assume from the PKTT, availed himself with 2 cell phones in a evidence bag. The cell phones were still on. I'm not sure why they were on, but they were on. We had a cyber expert on standby so that the download of those cell phones and the execution of the access warrant was done properly. The official stayed in the room. The investigators from Idac dealing with the matter were present. The cell phones were downloaded. They were put back in the bag, handed to the official. To date, what we have is data. We were never in possession, save for the time of the actual download of any of the electronic devices of Mr. Matlala. But during the download process and in the presence of the police official who brought those cell phones, the cyber expert made it clear that there were gaps as it became apparent that data had been deleted. Of course, that would have to form part of his report when he makes his report as to when data was deleted and or that there is information missing. We then got that data. We have continued with the investigation into the allegations relating to the SAPS tender. There are many persons that are implicated, both within SAPS as well as Mr. Matlala and some associates. That investigation continues, and that is how we became involved in that matter. The only matter that Idac currently is looking at with regards to Mr. Matlala relates to the 360 million rand tender. Other tenders relating to the Tembisa Hospital, Honorable Chair and members, is dealt with by the DPCI, and we are aware of those matters because in these weekly meetings, those matters also do get discussed, and we do have an arrangement that should we require any information that we are unable to procure, they would sort of steer us in the right direction in terms of the Matlala matter, but that hasn't arisen because we were able to deal with the matter as we have it. So that's the only investigation, and that's the only time Idac has dealt with Mr. Matlala and or had cause to have access to any of his digital devices. It was just 2 cell phones.
Now this referral on the 16th of February this year, where did this referral come from within SAPS? Your statement just says a referral from SAPS. Who in particular referred the matter to Idac?
The head of their risk audit referred the matter to Idac in terms of a Section 27 referral, deposed to an affidavit, attached supporting documents, and the matter came over to Idac.
And when would you first be alerted to this, or when would you become involved in this referral, if at all?
So, Honourable Chair and members, when matters are referred, they almost invariably come through one of the chief criminal investigators and or more so through the head of investigations and operations, Mr. Matthew Sissoko. So they would receive the matters, go through the matter at a cursory perusal, see whether or not it's a matter that Idac can take. They then compile an application, which we call a Section 28 application, for the ID to consider whether or not to authorize an investigation. That is the only time, or the first time, that I then become involved in applying my mind to the matter. Here the matter was then authorized, and when it is authorized, investigators and prosecutors, etc., are designated to conduct the investigation of these matters, as it's a prosecution-led methodology. But the investigators and the prosecuting team go about determining what taskings, activities, line of investigation, etc., should be followed. It is not for the ID.
So there would first be what sounds like a preliminary investigation that you would authorize?
Chair, for clarity, there are two types of investigations. Usually when we get the Section 27 referrals, it also depends on the level of information and or evidence that is provided. There are times where you can authorize a full-blown investigation, which is a Section 28(1). But in most instances, and to err on the side of caution, we, or the ID, is able to declare a preparatory investigation, which is a preliminary investigation. It is allowed in terms of Section 2813 of the NPA Act. And as the investigation progresses and they are able to find evidence of the alleged criminality, and there is more than a reasonable suspicion of the allegations, the team has to bring another application to say, at the point where we are at, this can now be a full-blown investigation. There have been matters, just for clarity, Chair, where we authorized the preliminary. After the investigations were done, there wasn't anything to take it forward in terms of sufficient evidence as part of the investigation, and those investigations can be closed. So it's not automatic. It does not automatically progress from one to the other. It depends on the evidence.
So how soon, or when after the 16th of February 2025, when the referral was made, did the request to authorize a further investigation, for want of a better word, was that authorized by you?
It would have been within the month.
Within the month?
Yes, because what happens, Chair, is if they sit with it, they can't do anything with it. They have to have an investigation authorized, albeit preparatory. And what it does, Honorable Chair and members, is there are certain processes that can only be activated. So, for example, the request for bank documents, the request for cell phone data, the request for company documents can only take place once you have a Section 28 authorization. And Section 28 authorizations, therefore, by their nature, allow for the activation of legal processes to obtain information. So they have to do it as soon as they are able to put it together, or else it's a piece of paper you're sitting with. You can't move with it when it's not authorized.
I just heard you saying on the tender of 360 million, there are a lot of people involved, including police officers and service providers. Is Minister Mutkunu and the former Minister Kele amongst the people that you are looking at?
Honorable Chair, it would be irresponsible to mention who potential suspects are till we get to evidence. Honorable Malema, I have learned that you can throw a name out there and then you follow what you think is an investigation path, and it does not amount to evidence. It would be irresponsible. You cause irreparable harm. But what I can say is there are several persons implicated, and regardless of their ranking and who they are, and whether they're public or private officials, as long as there's evidence, Idac will follow that evidence, Honorable Member, and where we can, they will most certainly be prosecuted.
Maybe let me put it differently. You were able to say police officers, high-ranking police officers. Are there politicians that you are looking at without mentioning names?
That is correct, Honorable Member.
Thank you.
May we proceed? Thank you so much.
Thank you, Honourable Chair. In the referral, this is now in relation to Matlala and subsequently the application, the internal application to you to authorize a further investigation. Can you give us, I know in your response to Honourable Malema now, and one can understand these matters are sub judice and your concern about fairness to the accused persons and a subsequent fair trial. You don't want to jeopardize that. But can you give us some idea of what was in this referral? For example, was there any mention about the PKTT? Is there any mention about General Mkhonazi? Was there any mention about Lieutenant General Khumalo?
Honorable Chair and members, not in the documents that we received.
Yes, the referral.
Yeah, not in the referral that we received. We received a referral that talks to irregularities in the awarding of the 360 million rand tender to one Vusimuzi Cat Matlala. It refers to police officials, but General Khumalo, General Mkhonazi were not mentioned in that referral. Nor was the PKTT, sorry. It refers purely to the tender process, and other members of the South African Police Services within the supply chain of the South African Police Services, the bid evaluation committee, the bid adjudication committee. That is where it stopped. There's no reference to any of those that you've mentioned, Honourable Chair.
And just again in your response to Honourable Malema, when you confirmed, I think, that a minister or ministers are also mentioned, is it in the same referral?
So, to be clear, it's not ministers that are mentioned. There are allegations that politicians are involved, and so we have to determine who these politicians are and what their level of involvement was and whether that involvement then amounts to criminality. In a lot of them, they also would talk of, for example, other persons affiliated to Mr. Matlala. No names are provided. I guess as one does the investigation, you have to look at who in that entire value chain would have been compromised and or complicit in the awarding of what now turns out to be a tender that ought not to have been awarded to Mr. Matlala.
We looked at the investigation into Kat Matlala, and also you were explaining your role in the whole process. So maybe just continue with that from the time you get a referral and then there's an application to authorize an investigation or further investigation. Just expand on that.
So once the investigation is authorized, Chair, whether it's a preliminary investigation or, in our terminology, a full-blown investigation, the investigators and prosecutors that are designated, they sit and work out what the line of investigation is, what evidence or documentation they would require, from whom and where. They have timelines for the investigations, and they will also determine the kind of resources they might require in order to conduct that investigation. And they go about their business. They will engage the ID, for example, if there is something that is required, and given our stakeholder relationships, there are instances where it is better, as we have also done with the National Commissioner of Police. More often than not, we will first write a letter making a request, for certain things. So there are instances where, for example, they would come to the ID and indicate what they need, and we rather follow that recourse of writing a letter and requesting information. Of course, then when we need it for court-directed purposes, we then agree with the person, we're going to have to serve you with the Section 28 subpoena, especially for issues of chain of custody and evidence. The investigations will carry on.
Honorable Skosan. Thank you, Chair. I just want to find out the clarity. As you sit there, you just said that there's allegations against politicians, am I right? And as you sit there today, you don't even know who those allegations against today. I'm talking about today.
I am not saying we don't know against whom. It is irresponsible to be throwing names of persons who might be implicated when the investigation is not yet completed. And so the level of evidence against them might either result in us having to charge and prosecute, or it might be that they are mentioned, but there is no evidence. So the investigation continues.
Thank you, Chair. Honorable Ngola, are you fine? Let's see, we may proceed.
Thank you, Honourable Chair. Sorry, Advocate Johnson, we were talking about your role, if any, in any, from the time there's a referral through to an investigation and then a decision to prosecute, and perhaps the prosecution itself. Maybe you would become involved if it's Oscar Pistorius, but your role in these matters.
So, Honourable Chair and members, once the investigation and prosecution team have concluded the investigation and they have determined that charges can be brought and they have determined against whom, what we tend to do before they put together their charge sheet, or what we also do is we ask them to put together a draft charge sheet, and they would present that matter to myself, some of the other deputy directors of public prosecutions who are not involved in the matter, as well as the head of investigations and operations, Mr. Sissoko. They'll talk us through the matter so that we can engage and discuss if we see any loopholes, if there's suggestions we can make on things that must still happen. But it's a collective back and forth engagement. And once that is done, the team will decide who the lead prosecutor will be. They'll put together a charge sheet. They'll also put together what we call a prosecution memo. And that prosecution memo, Chair, gets sent to the Director of Public Prosecution, in whose area of jurisdiction the matter will appear. Because in terms of the NPA Act, the investigating director enrolls after consultation with the Director of Public Prosecutions of that specific jurisdiction. So we send through the prosecution memo, they apply their minds, DPP will usually send a letter to say they have gone through the matter, you may go ahead. And then we enroll the matter as other criminal matters do in the normal course of NPA matters, and they run through the court system.
So, also just to be clear and understand, do you authorize the prosecution of a matter referred to Idac, or is the decision to prosecute the matter with the DPP in a particular province, or does the DPP just enroll the matter for a criminal trial? So
the investigating director and all the prosecution staff in Idac have a delegation and mandate to institute prosecutions for and on behalf of the state, similar to any of my counterparts in any of the other NPA offices and divisions. So it is not seeking permission to enroll the matter. It is to inform the DPP that we will enroll the matter in the area of his or her jurisdiction. However, what has happened is they can ask clarity from that prosecution memo. One or two have, we respond thereto, and then they indicate they are satisfied. But the institution of the prosecution happens by the lead prosecutor in the team. What the ID will do is, in going through the charge sheet, would approve that, yes, this is a charge sheet and that it can go to court. Honorable Chair, I think this hands.
Honorable Nomvalo.
Yeah, no, thanks, Chair. Advocate, I just want to be clear on this aspect. Does a referral only require you to prosecute? Do you not face instances where, for instance, a referral will come with evidence which is not complete, which requires you to do more investigation in order for you to establish prima facie evidence? Is it always the case that it requires you to prosecute, it comes with prima facie evidence?
Honorable Nomvalo, no. When the referral comes, investigation must get done. So an investigation must first be declared in Idac, and the investigation must be done. So even if we are given a referral with what others might consider substantial evidence, we have to declare an investigation. We have to check that that evidence is correct. We have to go back and talk to those witnesses. We take supplementary affidavits if we need to. We conduct further investigation, and only then do we prosecute. So a referral does not allow for an immediate prosecution. A referral allows for an investigation first. Even if we were given a docket, Honorable Nomvalo, we would have to first authorize in the Idac space, and investigations must happen, albeit just to verify. We cannot just run into a prosecution.
I'm okay, Chair.
Let's proceed.
Thank you, Honourable Chair. We just needed some clarity, because you talk about the team, the investigating team, and now the prosecuting team. The matter is discussed. The matter is discussed. But what is discussed? Are you discussing whether there are prospects, or what the prospects are of a successful prosecution? Or do you discuss matter, or is it already determined or decided by the lead investigator, lead prosecutor, that we are going to prosecute, and now you come in as the head of Idac to discuss various aspects of the prosecution where you may require further evidence, additional evidence, to strengthen the case or whatever? Just to understand your role in these matters.
There's no separate teams. A team will comprise of a deputy director who would lead the team, and there's chief and criminal investigators. There's a project manager who will manage. There can also be data analysts, and if we need external service providers are also designated to the matter. So at the stage it comes to the ID and others for presentation, it is for the team to present their evidence, what the allegations are, what evidence they have to support those allegations, any challenges they may have encountered, what it is they would require from the ID or the head of operations, or having given us that brief, evidence, charges, what supports it, what's the next steps, that they are now ready, they would like to have the matter enrolled, and then the administrative processes start. What they would need from the ID is to indicate, once they've provided a charge sheet and the prosecution memo, is that the ID approves that they can go ahead, but then we have to engage the office of the DPP first.
Have you, or do you, or can you interfere with that process of prosecution? And are there instances, have there been you, for good reasons or for no reason, decided no, this matter should not proceed to prosecution?
Honourable Chair, I cannot interfere in a decision, but I have to apply my mind to the evidence, to the allegations, what it is they want to do. We make proposals. Sometimes there may be more evidence that we can point them to, and that is what we do, and we advise on the matter. There has been 1 or 2 instances, like I indicated, where you have a preparatory investigation, and when you go through what they present, it's insufficient for a prosecution. Then that decision is made in consultation with that team. I don't sit on my own and say, no, this is not going to work. We're not going to allow this. There's an engagement, and when the team knows and understands, the team will then send a closure report indicating that for these reasons, we make the proposal for the matter to be closed. It's also done in a formal way.
Is there some inbuilt internal mechanisms to review any decision you might make? Or are there instances where it has happened?
So the review mechanism is where, for example, what we do have, and especially in matters that have gone to court, accused persons have the right to make a representation. They will make a representation which would first come through the prosecuting team to the ID. If that representation is unsuccessful, as is with every other matter in the NPA, they have a right of review through the Office of the National Director. So there are review mechanisms to that decision. And in that representation, they can indicate why they believe the investigating director and directorate made the wrong decision to prosecute, and they can provide the necessary evidence which would have to be taken into consideration by the National Director. I think at this point that function in her office is also delegated to the Deputy National Director of the Prosecution Services. At this time it's Advocate Mzinyati. Previously it was the late Advocate Rodney de Kock. But there are review mechanisms that are applicable to prosecutions across the board.
And just because I think it is quite an important matter that was raised by Honourable Malema in relation to the judge, the overseeing judge. Would a matter that has been referred on review to the NDPP's office, and where that office concurred with a decision not to prosecute the matter, would such a matter, in terms of the mandate of the judge, go to him, or can it be referred to him?
I'm sure that it can, if what the persons allege might be a malicious prosecution, a compromised investigation. Those would therefore talk to the integrity of a prosecutor and or an investigator. And of course, I see no reason why it shouldn't go there for the judge to apply his mind. And whilst you're on that point, if I may, Honourable Chair, on that oversight question, the Parliament has been the oversight body of the NPA and therefore Idac by its nature. So over and beyond the steps that I mentioned of bodies in the NPA. So that's the oversight. But I take the point that the Honourable Malema makes. We only have a judge now. And it is in this process that one is going to be able to determine the value of having this kind of different oversight mechanism that hasn't been a feature of the NPA before, and only because we have investigators and prosecutors under one roof in one agency.
Now, there's also an office in the NPA that's been established. I think, forget the full name designation now, but the Office of something integrity.
Is ethics and accountability.
Ethics and accountability. Would that office have oversight responsibilities over the work that Idac does?
They would have had up until the appointment of the judge. All complaints that relate to Idac must go outside of the NPA to the judge who's been appointed. So the NPA does not oversee those allegations. The NPA will still, I guess, of course, look at misconduct issues, which are labor issues, but complaints against Idac officials will go to the judge designated.
Okay. Now, just to get a bit closer home to the matter that we're dealing with specifically and to the allegations of Lieutenant General Khumalo, he says in an affidavit that has been placed before us that despite its mandate and the way you've described it, Idac has elected to involve itself in labor matters. And he refers specifically to the arrest of Lieutenant General Khumalo on the 28th of June 2025, along with 6 senior members of management on charges of corruption relating to the irregular appointment of Brigadier Makwele, and the records a Brooklyn case number. It is important to note that under normal circumstances, irregular appointments are addressed through established human resource procedures. In this instance, however, the members of the selection panel responsible for Brigadier Makwele's appointment were arrested and formally charged. The peculiar exercise of criminal jurisdiction over a labor matter warrants further scrutiny. And then he says, I was further informed that members of the PKTT have been the subject of several unwarranted cases as a result of their work. Although the cases themselves are without merit, they serve to distract members and instill fear and undermine the team in the eyes of the public. And then he records certain cases, referring to December 2024, the accused, Usumuzi Matlala, was advised to open a false case against members of the PKTT. Then there was also a case opened by Ms. Fundiswa Nyalungu, the partner of accused Mr. Katiso, KT Molefe, and by 2 of his nieces. It refers to the case numbers. In January 2025, Captain Makhotloi, a ballistic expert with forensic services, opened a kidnapping case. And during April 2025, Brigadier Shabalala from the DPCI head office initiated a case, Eastern Cape case, involving allegations of theft under the Corruption Act. So that is by way of background in relation to the broad allegations made by Lieutenant General Nkwenazi. Can we perhaps deal specifically with the matter of that resulted in the arrest of Lieutenant General Khumalo? When, to your knowledge, did this saga begin, which resulted eventually in his arrest and subsequent appearance in court, and I believe also again today to amend or to relax his bail conditions?
Honorable Chair, before I proceed, I don't know if Honorable Songani still has, she had her hand.
Yeah, we did not want to distract the SC. What do you want to do? Do you want to take a question first, or do you want to answer the SC?
Maybe she had a point to it that she would want
Okay.
to make.
Let's take Honorable Sangwan.
No, thank you, Chair. No, it was a small point, just clarity. When the SC was reading, he started off saying in an affidavit deposed by General Kumar. I wanted to make sure that it was
Yes.
General Mkwana's. No.
I concur, he did say that, Honorable Member,
Oh,
and I was going
sorry,
to ask.
did I say Kumalo?
Yes, you said Kumar. Oh, no. So it was Mkwana's.
It was Mkhonazi, and it's an affidavit that is attached to his statement before the committee. Thank you.
Thank you, Honorable Chair. I will deal with the arrest of Lieutenant General Kumalo, but you made mention of quite a few things about the PKTT, and I would just, for purposes of completeness, indicate that Idac is not aware of these cases that were made, be they by Mr. Matlala about theft, by Katitso Molefe, the ballistic case, or any other case that has been made against any of the PKTT members. They are not allegations that Idac is looking at, and so I am, unfortunately, Chair, unable to provide this House with any information with relates or with regards to those matters. I'm not saying that there weren't cases. I also cannot comment on the validity of these cases and or not. That's not my place. What I can then indicate, Honorable Chair and members, is early in November 2024, Idac did receive a Section 27 referral from Mr. Adams. To be clear, the ID herself hasn't met Mr. Adams, nor have I spoken to Mr. Adams, nor have I engaged Mr. Adams. And the reason for it is simple. Matters that are referred to Idac must come through the head of investigations and or the two chief criminal investigators. That is how it works. And so I hadn't had any engagement. The Section 27 referral comes through in November. The investigators have engaged with Mr. Adams. His affidavit is taken. They then present an application for an authorization, as I've previously explained, as part of process, and the investigations are authorized. What was presented, Honorable Chair and members, is in terms of the collective matters that were referred by Mr. Adams, it wasn't one matter. As it stands in Idac, they translate to 6 different matters. But the Section 28 referral looked at the collective complaint. And in terms of the collective complaint then looked at whether or not the bypassing of processes, the manipulation of processes and systems, the gratification in terms of the form of an employment, etc., fell within the ambit of state capture as we know it. Not the state capture per se of the State Capture Commission matters, but within the broader definition of what that capture meant. When we determined that the full ambit of those cases fall within that definition, the matters were then authorized. Currently, 2 matters are in court.
Can you just pause there and describe to us what define the characteristics of what is regarded as capture, state capture?
So Chair, we have always, through the process of deciding whether or not, in the broader sense of the word, there is capture or state capture, we have looked within the ambit of the State Capture Commission report, and as I have referred in paragraph 37, if you would allow me to read, it says that according to the Zondo Commission,
Yes.
and there it's the State Capture Commission report, state capture is a project where a group of actors with their network of collaborators systematically conspire to redirect sources for their own private gain It's achieved by the improper influence of state appointments and procurement and manipulating the rules and procedures of government's decision-making, undermining oversight mechanisms, and weakening key state institutions like law enforcement and intelligence services. We then had to look at what those different allegations were. And I know that, and I do say in the affidavit, Honorable Chair and members, if you just take the Khumalo matter, just stand alone. Of course, the members of this House can say, what were you doing? That is a standalone matter. What is it doing in your mandate? It is in our mandate in terms of there is corruption, then there's the argument. But that's not serious corruption. But what is serious corruption? Does the manipulation and bypassing of processes, putting people in strategic appointments, isn't that what got us where it got us to in terms of state capture? And then you say, serious? Is serious money? Is serious the offense and the office bearers who are entrusted with these positions, who bypass these positions? And then let's just say, I lose that argument. The Idac mandate can also look at fraud, which you would see in the charge sheet. It can look at issues of fraud, forgery, uttering theft, and any other matter that involves dishonesty. So as it stands alone, even on its own, and you take the corruption and you say to me, Madam Idac, it's gone. There are still matters that fall within the ambit of Idac for it to investigate and prosecute. But like I said, we first looked at the entirety of the Section 27. When we go to court, we've taken them on as the matters as they stand, or else we end up, Honorable Chair and members, with issues of misjoinder and charging people for different things where they shouldn't be in the same matter. And so we were able to then, as part of this process, start with matter one, which was the arrest of the Chief Financial Officer for the defeating and fraud. And then the second matter would therefore relate to the matter that we now discuss, which would be the arrest of Lieutenant General Khumalo and others.
And so there are 4 other matters.
There are 4 other matters that form part of the umbrella of matters that were the Section 27 referral that were sent through.
Honorable Malema.
Sorry, Madam, you were interrupted when you were trying to give us example of 2 cases. You said there are 2 cases and then you stopped there.
Honorable Malema, there were 2 cases that are already in court. The first case relates to the criminal allegations against Chief Financial Officer Major General Lushaba of Crime Intelligence. That was the first matter that was enrolled. And then a little over 2 weeks later, the matter relating to Lieutenant General Khumalo and the 6 other accused was enrolled. There are 4 other investigations that have yet to be enrolled because those investigations are not yet complete, but they arise out of that Section 27 referral. I hope I've provided clarity.
So, in those cases, do you find the name of General Mkhwanazi in there and the National Commissioner being part of the referrals that were sent to?
In terms of the Section 27 referral by Mr. Adams, I can tell you that I don't recall being briefed or seen in the referral itself for the authorization the name of General Mkhwanazi. And also with regards to the National Commissioner, I haven't seen his name other than, I guess, as the investigations progress. And to be very honest with you, Honorable Malema, I haven't had a briefing as of recent, so I cannot tell you about the National Commissioner and whether or not his name does appear.
But there was a story that there is prima facie evidence that is in your position against Mkhwanazi and the National Commissioner, and you are reluctant to charge. And if that is the case, will that not be defeating the end of justice if there is an overwhelming or prima facie evidence before you and you are reluctant to charge because of certain names, irrespective of who they are?
So to be clear, Honourable Chair and members, those allegations do not come out of the Section 27 referral. When I took over as the head, as the ID, there were already corruption matters that had initially fallen within the ambit of IPID. Those IPID investigators, when they were brought over to the ID at the time, came with their cases.
Are you okay, Honorable?
No, she was still responding to my question.
You will indicate if you are.
It's not me, it's a honorable member from Eastern Cape.
May I be allowed to finish, and then if Honourable Ngola will then be allowed to ask. Thank you, Chair. So those allegations do not arise out of the referral. They were corruption allegations that were initially reported at IPID. Idac is not afraid to act. We can only act when we have sufficient evidence. And just because there's a complaint doesn't make a criminal charge. And that is why where we are at, Lieutenant General Mkhwanazi and General Masemola have not been arrested for those matters.
Honorable Ngola.
Thanks, Chair. No, Chair, I was not trying to interrupt the honorable member from Sashego Limpopo. I was just indicating so that after he's done, you note me. I just want to get to one thing. Maybe the Advocate Johnson must take us to where does Idac derive the arresting powers? Which law do we give them the arresting powers?
Honorable
Thank you.
Sangoni.
Chair, I want to call a point of order. You see, Honorable Malema and Honorable Ngola have been away from the Ad hoc committee so long they've forgotten what a clarity-seeking question is. So they are starting new questions, and we need to wait until the evidence is led. Then they come back and they ask their questions. Please, Chairperson.
Okay. The part that says they have been away, they might have forgotten. I disagree with it. I sustain the latter part that says. But look, questions that emanate from the line of questioning by the evidence leader are acceptable. Yeah. Can we proceed in that way? If a question emanates from the line of questioning, I don't know the question about the mandate of Idac, if it is related to what the SC was leading now. Yeah. May we proceed?
Chair, can you rule that my questions were not out of order? Being away after you have apologized doesn't mean you have stayed away from struggle. I'm here.
Look, the away part does not belong here.
But my questions were in line with what the SC was asking.
I agree with that,
Thank you.
with that part. That's why I say the part that both of you were away, let's not belabor it. SC, may we proceed?
Thank you, Honourable Chair. So the four other cases being investigated, they arise from the same Section 27 referral by Adams.
Sorry, Honourable Chair. I don't know if it looks like Honourable Ngola is still unhappy, but maybe if he, without me going into the detail, if Honourable Ngola will go and read Section 29A, subsection 1 and its various subsections of the National Prosecuting Authority Act, as well as the Act as amended in 2024, to deal with the question that he raised. Thank you, Chair.
You will come and explain that later when he is asking you. Now let's go to the SC.
Thank you, Honourable Chair. Advocate Johnson, yeah, I asked for you to confirm that the 4 pending cases being investigated, they arise from the same Section 27 referral by Mr. Adams.
That is correct, Honorable Chair.
And I know you wouldn't want to mention names, but at least you can tell us these 4 other matters pending and being investigated, do they involve the same or all or some of the 7 accused in the Khumalo matter, including Lieutenant General Khumalo?
I'm not going to go against my own principle that I espoused in this House. What I can say is those 4 matters relate to the crime intelligence environment and allegations of criminality in that environment.
Better be careful, your husband is also in that environment.
And if my husband does wrong, Honorable Chair and members, I think, and to be fair, let's deal with the question. There are consequences. One of the things I have always stood by, I'm not prepared to. He's an amazing husband, that's an aside. I'm not prepared to compromise my integrity or oath of office, not even for the husband, not at all.
Yeah. So let's just deal with, you mentioned that you don't know, you haven't met Mr. Adams. You mentioned in your statement, though, that I'm looking at paragraph 44, that when he approached Idac, he had already gone twice to the SAPS in the Western Cape and Gauteng provinces. We had open cases. And then you say, somewhat miraculously, these cases had disappeared. Now, do you have first-hand knowledge of this, or are you just conveying information that came to your knowledge at some point?
So, Chair, this came to my knowledge through my own investigators who had taken the Section 27 referral affidavit from Mr. Adams. So part of what he indicates is that when he received information, which he alleges was pushed under his door, which is part of the affidavit, that he opened cases in the Western Cape. He later opened cases in Gauteng. Nothing came of either or, and these matters then were referred to Idac. However, what Idac did find on the first arrest, the first matter,
Yeah, if you can conclude your answer.
is it okay, Honorable Skosana?
Conclude your answer, Advocate Johnson, and
So,
then Honorable Skosana will be given an opportunity.
Honorable Chair, I'm not sure if it is appropriate to raise. I know, I said, I do not know Mr. Adams. I've never met Mr. Adams. I've not spoken to him, but I have seen him on television. And it is somewhat of a challenge for me, ethically. We are discussing a criminal matter in which Mr. Adams is a complainant, and I do see that he is sitting in the House. What can happen later during a criminal trial, accused are allowed to say that their matter was unduly influenced by his presence. I'm merely raising it, and for the Chair and House to decide how you deal with it.
You don't know him, but you see him.
No, not knowing a person is one thing. I've seen his face on television.
Oh, okay. The face you see is the face you saw.
I wouldn't know whether it's a kilogram heavier or lighter, but yes, it's similar.
Okay. SC, how do you deal with that matter?
With Mr. Adams being in the house or in the room? I think we need to be consistent in the same way that we've dealt with some other honourable members. remaining in the House, and despite being complainants in cases. I don't think, Advocate Johnson, there'd be any prejudice. Perhaps, I don't know, maybe getting a fright that you're seeing him here today. But apart from that, there's no prejudice to the case. He is a complainant in a matter.
To be clear, Honourable Chair, I didn't talk of prejudice to the state's case. We also protect the rights of accused persons, and I do not want accused to raise later on that certain details were discussed and the complainant thereof sat in a house where they didn't have representation and or were not present. I merely raised that ethical issue.
Well, you can go outside now, Ms. Johnson, and look at it on TV. It's going to make any difference.
You can take Honorable Kona Panat with you.
Honorable Malem.
Just to put it on record that Adams is not a member of this committee. He's a member of parliament. And like any other member of parliament, his rights are not withdrawn. He can attend any committee as a member of parliament. So this is a completely different space. Hence, before she took an oath, you have had to remind her that certain things that are done here may not even be used anywhere else outside this place. So it's for Adam's personal conscience that he left, which for me is good, but it should be put clear that he's not a member of our committee, he's a member of parliament, and it doesn't influence anything when it comes to how decisions are going to be made here. Thanks.
Honorable Skosana. Thank you, Chair. I just wanted to make a follow-up question about the issue of Honorable Member Adams. Did Mr. Adams bring up a classified document in his report? If so, are you authorized to investigate a classified intelligence, and which specific section allows you to do so? Because according to the law, only the Inspector General of the Intelligence Office has the authority to investigate such matters.
Is that question based on the evidence that the SC is leading?
Yes.
Okay. Number one is that, yes, it's true that Mr. Adams is not a member of this committee. And number two is that he is not leaving the proceedings because it is a decision of the chair that he must leave. And number three, when questions are put to you, advocate, and in your conscience you have an understanding that it has an element to prejudice any person, you can always raise that to say, I believe that there is an element of prejudice in this question, and these are the reasons that I advance. Yeah, but when he left here, it's out of his own conscience. It's not because we have taken a decision that he must leave. Honorable Sangwen.
Thank you very much, Chairperson. And I mean, I know I don't have to, but I concur with your summary as well as what Honorable Malema had raised. Honorable Chair, I'm really not trying to be difficult, and I'm appealing to members. Just in terms of the process and procedure we had established on this issue of the follow-up, I mean, the clarity-seeking questions. The questions that members are raising are excellent questions. They are very important. It's just that they're not for right now, you know, including the question that Honorable Skosana raised. Let me tell you why I'm saying, Chair. In our very first meeting, I remember I attempted to do what the member was doing, right? I was interested in a point, wanted to pursue it. Honorable Madlema corrected us, even made an example that you asked things like, no, is it this one? Who do you mean exactly? I did not hear that word, you know? So if we could please maintain that, Chair, then when members have their time to ask questions, then any and every issue that they want to interrogate, they can do it at that point. I'm appealing, Chair. Otherwise, we won't finish leading the evidence. Thank you, Chair.
You talk about questions asked out of impatience. Okay. Honorable members, and I asked that question, Honorable Skosana, because I believe it's a question that can still be responded to later. But if you strongly feel that it must be answered now, I can concede to that.
Chair, I wanted clarity. It's no longer a question time for me. Can you please answer now? Because we're on that matter of Adams about what Adams brought. So I just wanted to find out about
What
that.
is the clarity you seek? No, yes. What is the clarity you seek?
Must I repeat the question again?
Yeah, the clarity seeking question.
So must I repeat it again? Whether advocate through you, Chair. You want me to repeat myself?
Honorable Skosana, I did hear you.
Thank you.
May I proceed, Chair? I'm going to answer without going into a whole debate, and I accept, Honorable Member, you will come back with more questions when it is your turn. Safe to say, what the ID herself received was a Section 28 application based on a Section 27 referral. The investigators got an affidavit from Mr. Adams. But let's just say the ID was given a document purported to be classified. The ID is in possession of top secret clearance that therefore will allow me to look at those documents. However, before we do that, even with the SSA matters, Honorable Member, what we tend to do to err on the side of caution, we would indicate to the person giving us a document, can you rather declassify before you give us? But I did not have sight to any classified document. Thank you, Honorable Chair.
SC, we have 4 minutes left before the next break.
You want me to proceed, Honorable Chair?
If you are generous enough, you may say we break. And if you feel we can still do something in 4 minutes, you can say we are a nation at work for a better life for all.
Well, we're dealing with this important matter now, so it might be convenient to break at this point and to resume after lunch.
Honorable members, we are breaking, we are coming back at 14 hours.